University Association of Ghana, that is TWAG.
Yeah.
What were the concerns? I understand that they are being on some fair wages and other issues concerning allowances over the period. They were promised it's not coming in, but the minister has hinted controller to fast track some of these things we've given to them. Were they at the commission yesterday?
Yes, they were at the commission yesterday. In fact, we received a letter from them on the 12th of May, 2025, indicating to us that they intended to go on a strike action because of what they termed a delay by their employer to grant them certain conditions of service, that is with regards to some allowances that they had agreed or reached a conclusive agreement with their employer. And so these matters came before the commission, and they were directed somewhere last year to go and then have a negotiation, which there were some level of agreements being reached. And what they were looking up to was for payments to have been effected. But it couldn't take place as of the time that they were expecting it. So they had written to the commission indicating their intention to resort to an industrial action, which the commission had to summon them for a hearing, ask them to stay all actions, or all intended actions, and appear before the commission, which was on the 21st of May, that is yesterday, fulfilling the conditions that are there in the Labour Act, which requires that before any organized labor institution will embark on a strike, they need to notify their employer and notify the commission. And so we summoned them for an appearance. And then it turned up a bit dramatic at the commission whilst they appeared.
You don't say.
The reason being that whilst they came, they had earlier in the morning
because I read
declared
a
nationwide strike action, which had taken us aback because the commission had invited them for a conversation so we could know what their issues were and know how to help at best to get the matters resolved, only to hear that they had taken such an action. And so whilst they appeared, the three unions made up of the FUSAG, the TUAG, and then the SSA of UOG were present, except the SSA of UOG that were not around. The commission found out that they were on strike. And per the laws that we work with, that's the Labour Act, they didn't have the locus to appear. And so the commission asked that they go and call off the strike with immediate effect, and then they come back to the commission for an amicable resolution of their concerns. And just after the meeting, we also had a SITRIP, that situational report, indicating to us that the Minister of Finance, Honorable Ato Forsen, has written a letter to Controller and Accountant General's Department, the Fair Wages and so on, to effect the payments that were supposed to be granted to them. You know, these agreements have been reached since last year, 1st November.
Yeah.
So, and it needed just implementation. Yeah, so he had written a letter to that effect for the payments to be made to the teacher or the educational workers.
So that's come?
Yes.
They're returning to work?
Yes, and we also heard in the news this afternoon, even though the NLC is yet to receive a copy from them, that they have called off the strike.
Yes, I think that the rep was spoken to one of the local radio stations, and then I was in a vehicle coming to work when I heard that they are putting together the official communique, but they've been able to send informal WhatsApp messages to their colleagues to go back to it. By the way,
that is fine.
It all forms part of our conversation, try to understand the work of the commission and then what goes into it. Let's start the conversation for today and look really at what your occupational challenges are like as a commission.
Yeah.
But before that, let's have a fair look, because from today, as at last Tuesday, last Thursday and in the past, anytime we speak, there's so much emphasis on what the Labour Act says,
Most exactly.
what the Labour Act is directing, and what premise is being given as far as the Labour Act is concerned. So just to make us understand the foregoing of the conversation, overview in brief, what really is the Labour Act?
Well, thank you very much, my brother. The Labour Act of 2003, which is the Act 651, was enacted on the 8th of October 2003. And the president by then, His Excellency John Ejekun Kufuor, appended his signature to it to make it a law. See, the reason being that before the coming in of the Labour Act, there has been a number of regulations and laws that were to say regulating the activities of labor in the country. There were about 17 different regulations on labor. Some of which were even criminal, so to say. Somebody could absent himself from work without any excuse for a period of a week, and he could be thrown into a cell for a day or two because of absenting him or herself.
For 1 week?
Yes. And there were a lot of things that these legal frameworks were having on the ordinary worker. And so the coming in of the Labour Act then came to put all these laws together and to codify it, so that now those that were supposed to be decriminalized were done in that manner. So it could now become a very living document that could regulate the labor space. The employer will know his responsibilities. The employee will know his responsibilities. Other things that goes into it, like leaves, protection of employment, general conditions of employment, and even the same law also came to set up the National Labour Commission.
Interesting.
That was one thing that was very fundamental in the law. It is the labor law that brought the National Labour Commission. And so before the coming in of the Labour Act, it was only the Labour Department, which was the central administrative arm of government, that was handling all labor issues. So anything in relation to labor,
The Labour Department.
is the Labour Department that was handling it. Whether it was on issues of strikes, it was on issues of termination, it was on issues of leave, it was on issues of anything relating to labor. It was the Labour Department that was handling it. But now the Labour Act came and it specified the role, the establishment, the composition, the powers, the functions, the regional committees, and even the district committees of the commission, granting each of these its duties, responsibilities, and so on and so forth.
Interesting.
And so the Labour Act had come to a large extent to help to break that monopoly that was existing. And so that has been the purpose of the Labour Act coming into force. And you know what? Whilst the Labour Act also came into being, because it's a law, we can refer it as coming into being, because it's also growing as the days goes by. Now, with the coming in of the Labour Act, there were other two legal frameworks that were also brought in to come and explain certain things that were not so clear in the Act. So these were legislative instruments that were brought after.
Okay.
Example is the legislative instrument 1822 and the 1833,
Okay.
which also explains certain things that were not so clear in the Labour Act.
So they provided more flesh
more
to what
flesh
the Labour
to what
Act,
the Labour Act had already come up with. And you see, the Labour Act takes its blessings from the International Labour Organization's convention, the ILO convention, because Ghana is a member of the ILO body.
Okay.
And I'm even pleased to say that in June, there is going to be an ILO conference, which industry players will be attending from Ghana in Geneva.
Okay.
So all these things come into play when before the Labour Act was enacted. So there were some nuggets that were picked from it. For example, hours of work, cumulative hours of work in a week, leaves, maternity leaves, and so on and so forth. All these were some blessings that the Labour Act picked from the ILO convention.
Interesting.
Yes. So that is one good thing that the Labour Act has brought.
In a nutshell, the Labour Act then gives more of like direction to the commission, checks your operations, and at the end of the day, too, the duties that ascribes to the employer and employee relations to all of them is contained in the Labour Act.
Yes. Yes.
So if I want to establish a business and then employ people, the first thing I've been able to get my resources and whatever be the case, once employment comes to mind, I need to akin myself to the Labour Act.
Exactly. You see, the Labour Act is the document that provides all needed information with regards to the legal conditions through which business can be established or work. Anything employer and employee relationship is the Labour Act that provides a definition to it. Likewise, the Act also takes some blessings from the 1992 Constitution. Yes. So the Labour Commission, like this, we work with all these documents, but mostly the Labour Act.
Interesting. I have a friend who works with a pension institution. So let me ask this. We are talking about employer-employee relations contained in the Labour Act. What about those who cross the threshold of active employees? They get into the ambit of pension, or even in the course of being active employees. What is ascribed them in terms of pension, tier 1, tier 2s, about other things? Do you also have oversight on that one too, or it has to do with a different body?
Well, those ones are handled, issues of pensions are handled with the National Pensions Regulatory Authority. They are also an agency under the Ministry of Labour, Jobs and Employment.
So they are all under one ministry.
Exactly. And then Social Security and National Insurance Trust. They are also handling the SNIT pensions of workers. So these concerns about pensions fall directly under the ambit of SNIT and then the National Pension Regulatory Authority, which the NPRA, for instance, has an act which they also work with.
Okay. Now let's come to the NLC and then the Labour Act. How do you draw funds for your activities, or in other way, how do you fund your activities and your operations so far as the commission is concerned?
Well, this is a question. Actually, it's actually a question. You see, the commission's activity is funded by government. In the Labour Act, it is government that is supposed to provide the commission with a working space, as in offices, and then tools to operate with.
Okay.
That is the work of the employer, and in this case, that is government. But you see, the commission is a tripartite one.
Okay.
It is made up of 3 bodies. These bodies are government, organized labor, and employers association.
Okay.
And so it is expected that all these bodies perform certain roles to help the work of the NLC. But in many a times, I can say unequivocally that it is government that provides resources for the running of the commission.
Okay.
The commission recruits staffs to work with, and it is government that pays them. Government provides us with the working space, the working gadgets and tools like mobility vehicles and other office equipments to operate with. Yes, it is on rare occasions that the commission gets some of these help from the other two partners, that is employers and then the organized labor. But they will have to be up and doing. They will have to be up because the commission is expected to do more. There is a saying that to whom much is given, much is expected. The commission is the only body in the country that is regulating or ensuring the facilitation of labor disputes and putting in measures to curb labor disputes.
Yes, you are providing serenity in the workspace.
Exactly. In fact, the work that the National Labor Commission does is of national security essence. The work is of national security essence. The reason being that if there is no peace on the industrial front, excuse me to say, even His Excellency the President of the Republic will never have peace. He can't sleep if there is no peace on the working front. So the Labor Commission is doing a yeoman's job. He's doing so well. When you take the number of cases that comes into the commission, and I want to limit myself to issues of strike.
Okay.
Last year alone, per our database that we have, we received not less than 23 strike cases. Those that were in, but of course, people will have to fight for their demands. When it's election year, people will fight for their pound of flesh. You see, and receiving 23 cases in a year, of which they are strike, and majority of them were from the government institutions, and majority from the education sector. Assuming the NLC were not to be there, it could have turned into a rampage. Everybody will get up and choboy, and then there is chaos and there is anarchy in the country. But for the timely intervention of the NLC, through its proactive work, when the commission even gets to hear that this party or this group intends to embark on a strike action, it quickly writes to them. Even if they haven't notified us.
I realize
through our media monitoring.
You act proactively. Yeah.
Exactly. We write to them and we summon them to appear before the commission so we can be able to address the concern that is there and it doesn't turn into a strike action. Look, when teachers go on strike, somewhere last year, I think early last year or last 2 years, TEU, NAT, NAGRAT,
early last year.
Yes, embarked on a nationwide strike. And my brother, there were a lot of consequences.
Yes, the strike where they're saying that due to galamsey,
it was of national security concern. Because now, whilst they went on strike, schools were closed down. And so if you are a worker and your child is not going to school, will you have peace of mind to go to work?
No.
Because you can't leave the child in the house.
We will be taking care of them.
Exactly.
And what are they eating? What are they doing at home by now?
So there were a lot of concerns. So these are some of the things that I can say on authority that the National Labor Commission has been able to curb.
Okay.
And it is a plus.
But we commend you highly. Like I keep saying that you're doing a very yeoman's job. But when you look at the tripartite that you made mention of, that when it comes to government, it comes to workers,
organized
union,
labor,
and
then employees.
The other two that are doing their bits, what has been their concerns so far over the years that they are expected due to the commission that they are not bringing? What is their concern?
My brother, I think this one I will also refer to you as a research to conduct, and then probably you come out with a paper on it for our study, because we can't fathom it. They are a part of the tripartite, and much is expected from them. You see, much is expected from them. They need to also put their shoulders.
I'm sure by bits of they being a tripartite, they are part of your board and other things.
Exactly. You see, when you come to the commission, the 7-member panel who sit on cases are made up of 3 groups. These 3 groups, we have 2 representatives from organized labor. When I say organized labor, I'm referring to the trade union. all unions in the country belongs to the organized labor. And then the employers, the employers association are also made up of all individuals who have established corporate organizations, businesses, and so on and so forth. They are part of organized labor. Employers association. And then government. So all these three bodies have two representatives each. And when it even comes to the choosing of the chairman, who is the seventh person, the government doesn't have a voting right. So it is organized labor and then employers association who nominates the person who becomes the chairperson,
of the commission.
Of the commission. So you realize that organized labor and even employers have an upper hand when it comes to decision making.
More than even
the government itself.
But the government is the one bearing all
But the government is the one that is bearing everything. You see.
So
I think that it is high time, they also come up. And then get to support the work of the commission.
So
that is how come certain times people say that the commission is in bed with government.
Yeah.
But that is not so.
But are you in bed with government?
We are never in bed with government. No. I have mentioned it severally.
Yeah.
That there has been instances that the commission has even taken government to court. Has taken government to court and have won the case against government. You see, there was an instance that there were some allowances that were supposed to be paid to teacher unions. I've forgotten the class of unions. And the commission has ruled that those monies be paid. And it wasn't forthcoming. The commission went to court. And then the court ruled in favor of the commission. And government was enforced to pay. So that is how it is.
We'll plead to the labor unions and then the employers associations. That's how you call them.
Exactly.
To make sure that you pay your due to what is to the NLC.
To support us.
To support, because
to support
after the
us
support, they will need it every day, every time, because the work they are doing for yourselves, for the government and for the country is of high essence that every little support that comes to them will go a long way to strengthening the balance that they keep holding.
And you see, interestingly, the reason why we are calling for all this support from these other bodies in the tripartite is that the commission adjudicates cases that inures to all of them their benefit.
True.
When employers have problems with their workers, they come to report it to us. We invite the workers, we invite the employer, we sit down and we are able to resolve it so that work can go on. Likewise, when organized labor also have problem with their employer, they also come to report it to the commission. We invite the two and we are able to address it so that work will go on. So you realize that we being an intermediary in labor dispute resolution has been very helpful to all the parties. So if they are committing resources into the work of the commission, I think it is in place.
Sure, they have to. You guys need to. You need to commit the resources. It's very needed. And now let's come to one of the things you've hammered on dispute resolution. When as a commission, what procedures do you deploy anytime you are notified or you come into terms with aggrieved parties between the labor unions as well as the employers association, or between in fact an employer and an employee? When these issues arise, what are some of the procedures you deploy?
Well, I would say that the commission uses the ADR process.
Okay, alternative dispute resolution.
Exactly. And then the legal process in resolving labor disputes at the commission. The ADR process, in the sense that the commission itself, established under the Act 651, is meant to resolve labor disputes through the alternative dispute process, so that it doesn't become much more of legalities.
Yeah, more of like an out-of-court settlement.
Exactly. Because when you go to court, let me even ask, how many ordinary people can go to court to file a case.
You don't have CAPLA, you don't do it.
Because you have to pay. But with the Labor Commission, our services are free.
Not pay for going to court, but pay the legal
Exactly,
person,
exactly. Filing the case and so on and so forth. You see, but with the Labor Commission, our processes are free. You don't get to pay anything. You don't get to pay anything.
So nobody gives you 1 cedi for resolving it?
No. And let me tell you, just quoting from my executive secretary, since the establishment of the commission to date, the commission has been able to give awards on settlement to the tune of over 300 million Ghana cedis.
You don't say.
Yes. To the tune of over 300 million Ghana cedis. And with this amount, we have had over 95,000 coming through the Labor Commission, which parties have come to receive their monies from the commission. And with all this, they don't even pay 1 cedi to the commission.
Oh, not even, thank you.
You come and we just pick up your money and we give it to you and you go. You walk away.
If they are doing working for Nyam, man.
You see, so in fact, there are a lot of things that has been going on. So the alternative dispute resolution process that comes with more or less the facilitation of the case when it comes, and that becomes our first step of dispute resolution process, the facilitation.
Okay.
So with this, the facilitation processes are carried out. The industrial relations team sit in panel and they bring the parties together and try to hear from them, know what their problem is, and try to help in resolution. Likewise, the mediation processes it also go through the more or less the ADR process, because the mediator is supposed to guide parties into a resolution.
So that they arrive on something.
Yes, to arrive on a settlement or a resolution. So that is about the ADR processes. And then the legal processes, of course, we can talk about the arbitration, the voluntary and the compulsory arbitration, or the summary settlement. See, when the cases goes through the processes of the hearing and it gets to the point that it cannot continue at mediation, the parties have an option to go for a voluntary arbitration.
Okay. Which is?
So with the voluntary arbitration, they are given a list of the arbitrators and they choose the one that they prefer to handle their matter.
Not that you prescribe to them.
No, we do not prescribe
but there's
to
a
them.
list of arbitrators you work with.
Exactly. We have a database of registered arbitrators with us and mediators. So the list is given to the parties and they now select the one who they feel they want to handle the matter.
Okay.
So that the person is written to and he then arranges a meeting either at the commission or at any place that is of convenience to both parties. So that they will go and sit there and then they will help in resolving the matter through the voluntary arbitration process. And then with the compulsory arbitration, this comes with when, for instance, say the group that are not supposed to go on a strike, essential service providers, doctors,
bankers,
even drivers,
media people,
Ghana Water Works,
or
the Ghana Water Corporation, Electricity Company of Ghana, they all provide essential services, the transport industry. So when these people have concerns, the commission, when it comes, the law says that if they are unable to resolve the matter within 3 days, then a compulsory arbitration should be triggered so that they will go through the processes
and then resolve
it. So the commission sets up the compulsory arbitration panel and they hear from them and give a directive or a ruling to that effect so that the parties can go and comply with it. Exactly. So these are some of the processes. And you see with the legal, and we have the summary settlement. The summary settlement is the final stage of the dispute resolution processes that the legal processes or approach to the resolution process. That one, it is the 7-member panel. The 7-member panel. And I say on authority
that happens
the
to be the
commission,
last stage, or it's also part of the processes?
No, you see, processes of here for at the commission, that is the final stage.
Okay.
The summary settlement is the final stage. But if parties feel that they are not okay after the summary settlement process, they have the liberty to go for appeal at the law court. They have that privilege. Yes. So I say that on the summary settlement, the 7-member panel sit and they hear the case. And they also use both the ADR and the legal process to resolve the matter. They deploy all this, because legal in the sense that when you appear before them, you are made to swear an oath. We have the Bible, we have the Quran, we have the cross. You pick and then you swear.
You don't have a calabash and tesbih.
No. Maybe that can be considered as an afterthought. So you are made to swear, and then the proceedings begin.
You see, and at that stage, the panel, where are they? Where are they? Staff? Are they commissioners? That are rotational, or is permanent 7 you have for some resolution?
They are commissioners. They are not core staffs. The day-to-day workers like we are of the commission. They are more or less, as others may call it in other institutions, others may refer to it like the board of the organization. But in our case, we call it the commissioners. So they are the 7-member commissioners of the commission. And they have a fixed term. They are they work within a 4-year mandate. So the current commission like this, their term of office or their tenure will be ending in June next year, 2026. And then a new commission will be constituted.
Which has no political involvement.
Yes, but then the government representatives will still be there, because they came in with this new government. So their 4-year term will not end next year.
Not up to 2028.
Yes, but for that of organized labor and employers, their representatives, their term of office will end, including the chairman. But they can also be renominated by their unions or by their tripartite they are coming from.
Oh, that's good.
Exactly.
That's good.
To continue with their work.
In these processes, do we find the parties being cooperative to the laid down modalities and procedure that the commission has in resolving disputes?
You see, those have been some of the very difficulties that we have had. See, certain times the cooperation are limited. Most especially on the part of the respondent. And in many times, the respondents have been the employers. The employers. I will say that about 65 to 70% of cases that we receive at the commission are lodged by the workers.
The employees.
Against their employers. About 65 to 70%.
So just a few, cases, that is the other way around.
In a very remote case or remote cases that you hear the employer coming in to lodge a case against the employee, you see. And when they are written to, what the Labor Act says is that when we receive, see the powers of the commission has the powers to receive complaints, to ask for evidences, and so on and so forth. So when they are written to, and they are asked to respond within the 14-day period which the Labor Act provides, certain times they flout it. They don't respond on time. And the law again says that after the 14 days, we should write a 7 days reminder. So if they don't respond after the 7 days, we write a 7 days reminder. And already 21 days is gone. Delaying the process of hearing.
So those who don't comply, 14 days. you rewrite 7 days. What happens after 7 days?
After
Do
the
you deal with
7
them?
days, you see, after the 7 days, if they still fail to respond, the commission, the law provides that the commission goes ahead to hear the case.
Without that they had the case ex parte.
Yes. Them. And in going ahead to hear the case, the law also says that the commission should still write to invite them to appear for the hearing.
We are doing the hearing.
Exactly.
You didn't respond,
give them the date and invite them that even though you didn't respond, but on this said date, we are going to hear the case. And so come. Now, I know you want to ask me if they don't come.
Because I'm surprised that I was like, those who wrote the law, then they are so kind-hearted.
And you see, that is one concern that the commission has. See, this is a power that the Labour Act did not give the commission. If we had been given a compelling power, I think it would have helped us.
The minister should
the Labour law didn't give us that compelling power.
At least they should give but you can have an ally on this one. That gives the commission more some level of
Interestingly,
power.
the act is undergoing a review. Okay. So some of these proposals have already been made, and we are hopeful that it will be factored into. So you see, even if they refuse to still respond, they will be invited for the hearing.
And do they come?
If they don't come, what the law says is that we should hear the other side of the case. And so you, the one who are the complainant, you will be taken on oath. You will swear an oath. And then the proceedings will go on. And so we will hear from you and adjudicate on the matter. And see, when the commission gives the ruling or the award in the case, whether you came or you did not come,
it is applicable.
It is binding on you. You are expected to comply with the directive or the ruling that the commission will give. And so if you are an institution and then maybe your employer has lodged a case against you for failing to pay him for about a year or two, and the commission goes through the processes and then it gives a ruling or an award against you to your worker, you are obliged by law to comply. You are supposed to comply. If you refuse to comply, the commission can go to court, and then your company can be closed down, or your company assets can be garnished to pay for the debt. That is it. That is it.
I was just supposed to look about applicability. Now, this is a situation where people do not come. But in the instance where people have complied, you are going through the dispute resolutions, like you have the parties, they come in, they bring in whatever it's supposed to be, and then the commission takes a decision. Now, per the experiences, you started a case where government failed to honor a decision that has been taken by the commission. In those cases, that in all instances that you go to court, or in some instances too, you give reminders to the parties who are expected to take certain actions post the decisions that the commission makes.
Well, when it so happens that the party refuses to comply with the directive of the commission or the ruling that the commission has given on the matter, we go to court. We trigger our enforcement process.
Okay.
We go to court for the enforcement of our decision, and that we go to the High Court to enforce the decisions that the commission had earlier given, so that the parties that are involved, or the party that is supposed to comply with the directive or the ruling, will now come to terms with what the decision of the commission has been, so they will comply. Yes.
After so many years, we are talking about from 2003 to 2025. That's more of like
about
20 something years
22
plus.
years now.
The trends of worker employer relations should have changed, and some conditions should have been enhanced by now. But when you just oppose, do you think that in prevailing times we need to do more in terms of the document, the Labour Act, that seeks to direct how these relations should be?
Well, to a large extent, I would say yes. by practice, there has been a number of revelations. You see, when the law is made and it is not being used, you don't see the loopholes that are there. But 22 years down the line, we have seen some loopholes in the law.
Yeah.
Certain areas that should be well structured, certain things that should be added, certain things that it can be taken off. You see. So currently the Labour Act is undergoing a review.
Okay.
It's undergoing a review. And some of these things, some recommendations have been made from the social partners. When I talk of the social partners, I'm referring in this instance the organized labor employers and then the government.
Okay.
They are social partners. They are all making recommendations, you see. And in practice, the commission have also made certain forms of recommendations so that it can be factored into the legal framework that will come out eventually. You see. And so there are steps that have been taken on this. For instance, did we ever know that a time will come that the whole world would even shut down, including Ghana? Until 2019, 2020, that COVID came. Did we even know that we could sit in our bedrooms and work from home? Everybody was getting up early in the morning, running helter-skelter, going to work, to go and sit behind desk and computers to work.
Meanwhile, we could work from home.
But meanwhile, we could work from
We
home.
didn't know until COVID happened.
Until COVID came. You see, even recently, even today, there was this lady who came to me in the office. And her complaint was that she has been working with an expert who engaged her remotely, went through a conversation remotely, and gave her a work to do. And they have been engaging in NGO work. And the person has refused to pay her. I asked her, do they have an office in the country? She tells me no. Do they have an administration that we can write to them to ask them to respond to us when we go through hearing process? She says no. So how do we get to write to this expert and then get response?
Oh my God.
You see, so a lot of things have changed over the years. Now people work remotely in their rooms. People are here in the country, they are working abroad. What are labor laws saying about it?
Yeah.
And you go into the law and you realize that there are no provisions for them. Meanwhile, they are workers.
Consultancy jobs.
Exactly. Meanwhile, they are workers. They are workers. So with the review process that the Labour Act is going through now, some of these informations have been picked. Some of these recommendations have been made so that the framers can look at it well and then come up with some legal documentations so it can bind parties that find themselves in these circumstances and also get to streamline certain things well. In the Labour Act, the employer can just get up and terminate at will.
Yeah.
The only thing he needs to do is to give you a notice or to pay you in lieu of notice. If you have worked for more than 3 years, he gives you a 1 month salary in lieu of notice or notify you 1 month ahead of the termination. And 2 weeks vice versa. You see, why can somebody just get up and then terminate your employment? Look at the conditions through which one even goes before you get the job to do. And somebody can get up and terminate you at will. So all these recommendations have been made so that certain things can be streamlined well, and it will help all of us.
In terms of enforcement and making things stringent, in the possible future, you think that the framers of the act wouldn't want to say that, okay, when we give too much leverage to the worker, we are going to bite ourselves in the foot or shoot ourselves in the foot in the future. Hence, they'll be dragging their feet, especially on the part of government and also on the part of the employers' associations, who are stakeholders, you call them social partners,
Yeah.
would have to be contributing to the redesigning or the reframing of the act?
Well, there has been a number of times that people have shared concerns, especially employers, have shared concerns that the Labor Act is even tilted towards
The employer.
the interest of the employee.
Okay, employee, okay.
Many a times, many of the things that the Labor Act is talking about inures to the benefit of the employer, the employee, more than the employer. You see, so they also have concerns. Everybody has a concern. Organized labor also have their concerns. They have also been talking about certain things that they feel that the employer is also giving a lot of leverage. And so with this review and with these new nuggets that are being picked from all over, they are going to be looked into. And then the best of ones that are of relevance, that can shape in and can help the labor front to be peaceful, devoid of these many rancor agitations and then, excuse me for the use of my language, unnecessary strike actions, which should not even come up, will all be reduced or curtailed, because the provisions that are going to be there. Look, now the labor law provides that groups can come out from their mother, can emanate from their mother unions. That is how come we had TEU GH coming out from TEU. That is how come we had Coalition of Concerned Teachers coming out from NAT.
Then we have NAGRAT.
And NAGRAT and so on and so forth. Meanwhile, when they were a bigger umbrella body, which was NAT, you could see that they were all united. And they also had a very solid front. My mom is a retired teacher.
Oh, okay.
So I know what I'm talking about. You see, but the labor law provides that there can be splinter groups. And so now there are a lot of splinter groups that are on the labor front. And they have all been given collective bargaining power or certificate by the Labor Department. They all have collective bargaining certificate, which gives them the audacity to go to call for a negotiation on conditions of service with their employer.
Because they have the certification.
Because they have certificate. And they can go on a negotiation. You see. So these splinter groups issues that has also become so much of concern will all need to be addressed. There are certain recommendations that have been made so that if there can be a way that the law can control it a bit, else there will be a time in the country that with one bigger umbrella body, there can be about 100 splinter groups all working under them.
I see it coming.
And they will have, yes, it can.
I see it coming because
If
I monitor
it can.
new groups that come up when
Exactly.
I May Day parade.
Exactly.
It's like every year I see a new
Exactly. You see, some of them may not necessarily have the bargaining power. Some of them may not necessarily have the bargaining power. But there are a number of them who have also been given bargaining power and certificate to operate with. You see. So that is how come today you see this group going on strike. Tomorrow the other group is on strike. But they all perform the same role. Because you have done it for this person, they also get up and they demand their pound of flesh.
One group that they have many pies is GPRTU.
You see,
they have different. They have, and they also have drivers union. Because I remember they have cooperative.
Yes.
Cooperative drivers something. Because there's a stretch. I used to stay at Adenton. We are going to pick a car. The GPRT people are the ones in the main thermal station, and then these people were able to also get a land by the thermal station that is opposite the entrance of the new AME building. They are there directly, so they are loading also Adenta Medina at that point.
So yes, so you realize that there are a lot of these splinter groups that are coming up as the day goes by, and something needs to be done about it. Something needs to be done about it, especially on the public service line of working. Else, like I mentioned, the time will come, we can have one big umbrella body with over 100 splinter groups, and they are all fighting for their pound of flesh.
One other concern, what advice do you give to broader employer and Ghanaian workers together, so far as the Labor Act is concerned? People do not know of their existence, or only those who think they want to know it. What do you tell them?
In terms of the law, you see, the law is very self-explanatory, and it is written in very flexible English
or language, yeah.
And the choice and use of words, that's the diction, is also self-explanatory. There are no ambiguous words and terminologies in it, you see. So it is necessary that workers and employers, unions, organized labor trade unions apprise themselves with the provisions that are there for them. It will interest you to know that there are instances that people appear, even union leaders, national union leaders, appear before the commission, and they are asked some basic questions concerning an action they have taken, and then they stand there and they are fumbling. It all tells the level of some people's knowledge that they have on the Labor Act and other relevant laws or legal framework that are also tailored on labor matters. You see, so it is of high recommendation that organized labor and employers especially try to find time and get to know of the provisions that are there. In fact, we have very excellent labor experts who are also on the field. They can even write to the commission. We offer such training services also. The commission can come in and train this group of workers or employers association on what the provisions in the law are. Just last 2 weeks, Ghana Employers Association invited the Labor Commission to train some group of employers on the provisions that are on the Act.
Interesting.
You see, so because the Bible says that for lack of knowledge,
my people perish.
They perish. And so when they are able to establish what the provisions are, it guides them. It becomes a guiding principle in the work that they do, and it is helpful.
Thank you, Totime. Our time is up. I have just a minute left, and then let me use that one to hype my niece. Celeste, are you ready with my picture? Are you ready? Selben, talk to me. Okay. So Totime has been taking us through the processes and making us understand some of the challenges that is confronting the operations of the National Labour Commission. So Totime, thanks for that particular conversation there. But before we go, let me hype my niece a bit. Today, she is graduating in the Bournemouth University in the UK as she finishes a diploma course in the International College. So big ups to you, Mariama Netili Neti. Mariama Netili Neti, she's on your screen there. That is my first niece. Beautiful she is. That's why I bought 2 guns. Yes, I bought 2 guns.
I also want to add my voice in congratulating
Thank you,
your
Totime.
niece.
Thank you, Totime.
Studies is not easy.
Yes.
So big congratulations to her.
Thank you. We've shipped it all the way to the UK, and she's making us proud. So, next month is her birthday. I'm going to throw a very big birthday party for her when she gets here. So I'll be throwing invitations to everyone that I know.
This reminds me.
Yeah. Thank you.
Tomorrow happens to be the birthday of my assistant.
Oh, over to you.
Julia.
Please do it. Let us flow.
I would want to wish her a happy birthday in advance.
Okay.
In fact, she has been of great support in the work that we do. If the commission during this period, the unit, especially the PA unit, have chopped any success, Julia has also been a backbone of it. And I congratulate her for such a remarkable feat.
Wonderful. Happy birthday in advance.
Exactly.
To Miss Julia
Puavi.
Assistant Public Relations Officer.
commission.
Of the commission. A very big happy birthday in advance to you. Wish you more grace and then more beauties to us, well. And then tomorrow, but we'll throw an invitation to you for tomorrow because my programs manager kept telling me that he wants to throw a party for you, Julia. So told him when we are done here, see my programs manager, Lester, and then but just him how you can just him. So you're able to do that. Big ups to the production crew. I see Gamache Kelvin, big ups to Kelvin, big ups to now, big ups to Blanksin, Sasu, Selassie, and then Lester, and then Niashi's here. He didn't come. Okay, so Niashi's supposed to come, but he didn't come. So we know. So big ups to all the crew over there. And today, my very special person, Gracie. Yes, Gracie passed by to just see us what is happening. So big ups to you, Gracie, and thanks for coming to us. Well, Totime, I hope I'll see you next week, and then all the best, and then drive safe.
Have a good night. Have a good night.
Big up. Thanks for being part of tonight's edition of PM Ghana, Television. Don't do what I wouldn't do. God bless our homeland Ghana and make our nation great and strong. See you on AM Ghana tomorrow morning. Have a good night. I'm out.